Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th, all which have...
But do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial equality.
You're not answering my question. I'm just trying to understand how you think.
Welcome back to Hot News Today, where I break down the Capitol's most explosive moments. Today, Senator John Kennedy took center stage, grilling Third Circuit nominee Jennifer Lee Mascott. If you missed it, buckle up. This was one of the most intense Senate Judiciary exchanges I've seen in a while.
Professor, congratulations. I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
Yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it at the time it was...
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
Okay.
Kennedy kicked things off with a bang. He wanted Mascott to spell out her judicial philosophy. No fluff, just facts. Do you believe in interpreting the Constitution by its original public meaning? He demanded. Mascott said yes, but when pressed for a plain English definition, she hesitated. Kennedy wasn't having it. Look me in the eye and just answer my question, he fired back. Mascott eventually explained that original public meaning means how everyday people understood the Constitution when it was written. But Kennedy wasn't satisfied. He shifted straight to Brown v. Board of Education. This is where things got heated. Kennedy asked, if you stick to original meaning, how do you justify Brown v. Board, the ruling that ended school segregation? Mascott sidestepped, pointing to later constitutional amendments, but Kennedy wanted a yes or no. The tension, palpable.
So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator,
but first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
Well, Senator, I don't know as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several fundamental amendments to the...
But isn't that inconsistent with your statement that you have to interpret it according to original public meaning?
Well, what about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean
what
with
about?
those... Well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th,
do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial equality.
You're not answering my question. I'm just trying to understand how you think.
If you find these moments eye-opening, hit that like button. It really helps more people see what goes down in these hearings. Next up, Kennedy zeroed in on ambiguous laws.
It's very easy to say we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case. So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute...
What do you do if it's ambiguous?
If it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
What should a judge do when the law isn't clear? Mascott explained she'd start with the text, look at related provisions, and avoid jumping to ambiguity. But Kennedy kept pushing, how ambiguous is ambiguous? 51%? Just a little?
No. How I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say I would use the same approach essentially in all cases regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that
Professor,
point...
I'm going to run out of time. With respect, answer my question.
Well,
okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Yeah.
So
why don't you just look at legislative history?
Well, you can't look at legislative history statements one by one because
Why not?
the individual
Why not?
intent. Senator, with respect, because this body has its role in our system as an institution, not one by one. So
Mascott cited judicial precedent like the Chevron doctrine, insisting courts can't just give up if the law's fuzzy. Finally, legislative history. Kennedy wanted to know if judges should care about committee reports and debates. Mascott played it safe, yes, for context, but never as the final answer. Kennedy grew impatient, looking for something more concrete. But Mascott stood her ground.
your personal understanding of the law doesn't matter.
This will be my last question. I'm sorry. Well, Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
So, did Kennedy get the answers he wanted? Not really. But one thing's clear, these hearings are just getting started and every nominee's word is under the microscope. If you want more sharp takes and Capitol Hill drama, subscribe to Hot News Today, and don't forget to share this video. Thanks for tuning in, see you at the next hearing.